have been provided. And the provisions begins from section 436 onwards. It is better first to understand what is actually bail. What is bail? As a common understanding, we all know about the bail. Bail is nothing but it is just a legal undertaking given to the court or any other officers as and when required to attend the court. It is bail is a kind of legal undertaking which is given to the court or it may be given to any other officer, police officer, undertaking of what? As and when required. जब कभी जरूरत पड़ेगा as and when required to attend the court. It is the bail. And you know the bail is not only always granted by the court, it may also be granted by the police officer. Okay. Bail may also be granted by the police officer. This undertaking, legal undertaking, is of two types. One is the personal undertaking, and other is the undertaking with some sureties. Surety or sureties. Whenever there is an undertaking with some sureties, that is the bail. This undertaking is taken by, or we may say that there are two types of undertaking. One is taken from by the personal bond, and the second is the bail bond. What is the personal bond? Where the person concerned or the accused himself gives an undertaking and certain amount is mentioned in that undertaking. If he is not, does not, or is not, or will not follow the conditions given in the undertaking, whatever amount was mentioned in that undertaking, he has to forfeit that amount by personal undertaking. The second is only personal undertaking is not enough, but accused is asked to bring some surety, the popularly known as, in Hindi commonly they are known as zamanti. So where other person, third person comes and on behalf of the accused, he gives an undertaking that the accused will follow the conditions of the bail, or he will present himself as and when required in the court, and it is our responsibility, and for that responsibility, the surety, certain amounts, which is of course is not defined in the CRPC. It varies from the gravity, from the case to case and state to state. That is the different thing. The third person of the surety mentions certain amount in their undertaking that it is our responsibility whenever this person is required in the court, we will bring that person. If it does not happen, if the accused violates certain conditions of the bail, their amount mentioned in the undertaking is forfeited. Okay. Now come to the provisions of the bail. Let us first Take section 436. Section 436, apparently it is about the bailable offense, but this section does not mention the bailable offense. What does it say? It says that any offense other than non-bailable offenses. When it describes like this, other than non-bailable offenses, of course, it is understood that it is talking about all the bailable offenses. Wherever there is bailable offense, in that case, the court shall, and you must appreciate these words in the different provisions of the bail. For example, in section 436, the word shall has been used. This is the only difference. In 437, the word may has been used. You know well what is the meaning of shall. Shall means the court has to grant. It is mandatory on the court or officer to grant bail to the accused. But there is certain relaxation, and that relaxation was brought in 2006 by an amendment. And that relaxation is, if the person is indigent, the poor, or is unable to provide the bonds, in that case, and if he is not able to provide the bonds within a week, it shall be considered that he is indigent person. In that case, that person may be released or bail may be granted even without the sureties. Right? I am going through the clause 1 of section 436. You have before you your bare acts. Let's see. 436 clause 1. 436 is about in what cases bail to be taken. In what cases bail to be taken? It says that when any person other than a person accused of non-bailable offense is arrested or detained without warrant by an officer in charge of a police station or appears or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceeding before such court to give bail, such person shall be released on bail, provided that such officer or court, if he or it thinks fit, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail means the undertaking with the surety, instead of taking bail from such person, discharge him on his executing a bond without sureties for his appearance as hereinafter provided. An explanation which provides that where a person is unable to give bail within a week of the date of his arrest, it shall be a sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this provision. What is the thing? The thing is this: it is clear, if there is a bailable offense, the court or the officer shall grant bail. Bailable offense means the person will have person has to be released on bail. But bail does not mean that a person is automatically released. He is not automatically released, but he has to apply for bail. He has to ask for bail. And suppose if there is a bailable offense and he never asked for bail, so though it is a bailable offense, even then he will not be released on bail. So keeping that thing in the mind, there is an exception. Sometimes it happens if there is an indigent person, poor person, and he is not asking for bail. If he is not asking, and further it is clarified that even for a week, it shall be considered that he is not able to apply for the bail and he shall be considered indigent person. In that case, he will be released without applying for bail. Second clause of section 436, bail means it is a conditional release. Conditional release means whenever court or officer grant a bail, there are certain conditions. And the accused has to follow those conditions. Those conditions must not be broken. If there is any breach of any condition, however it is a bailable offense, but his bail will be cancelled. Suppose in bailable cases, we have come to know in bailable cases the accused will have he has to be released on bail, no doubt about this. But when he was released on bail, after the getting the bail or after the release, he made certain breaches of the condition. For example, if the court asks as and when required, you have to come to in the court, and he does not appear in the court, does not come to the court. Because bail is an initial condition. Bail means the trial is going on. Bail does not mean that everything is over. Trial is going on. The court will certainly ask whenever you are required in the court, you have to come. And suppose he does not come, does not turn up, so what happens in that case? His bail will be cancelled. And he will not be released on bail. In that case, we can't say that it is a bailable offense. And anyhow he should be released. No. Because that is the second stage. And the same thing is given in the subclause 2. Subclause 2 says, notwithstanding, it is important, notwithstanding anything contained in subsection 1. Where a person has failed to comply with the conditions of the bail bond as regards the time and place of attendance, the court may refuse to release him on bail. Court may refuse to release him on bail. In that case, he cannot say, he cannot claim that it is a bailable offense. I am here, I am before the court in a bailable offense. He can't claim that. When on a subsequent occasion in the same case he appears before the court or is brought in the custody, and any such refusal shall be without prejudice to the powers of the court to call upon any person bound to pay the penalty thereof under section 446. 446 is about the cancellation of the bail. When the bail is cancelled, in that case, the surety uh, has to deposit certain amount, whatever amount was given in the undertaking, etc. That is the different thing. Is that clear?